right to privacy has been seriously discussed in not just in academics but also in the legal fields. So with this constitution clause, we have Personal Information Protection Act of Korea. So it is basically taking so-called opt-in way of protection of personal information. So therefore, so pre-allowance is required for collections, use, and provision of personal information. So actually, in almost in every situations and context. And Korea has took recent amendment of this act, so which was enforced from August 5th, which is quite recent, and it took in the compatibility clause and pseudonymize personal information with reference to the EU GDPR. So I can understand this basic act, and that amendment is the trial to take the balance of protections and utilization of personal information. So in this age of kind of big data or artificial intelligence. And academically, that constitutional basic right of privacy is named as private information self-determination right, or informational autonomy. Maybe you are also familiar with. And then I can go to the Article 37 of Korean Constitution, so which is prescribing that freedoms and rights of citizens shall not be neglected on the grounds that they are not enumerated in the Constitution. So in this sense, the right to privacy, or the right to personal information in the internet or database, so which can be somewhat different from the traditional privacy, because it is digitalized issues, and it is somewhat different in the sense of protections of infringement from the traditional privacy issues. So the Korean Constitutional Court is ruling that this right to private information stems from privacy, but it's not everything about privacy. It's kind of new kind of not enumerated in the Constitution, but it's still constitutionally protected right. And the second part of that Article 37 is saying that the freedoms and rights of citizens may be restricted by act only when necessary for national security, the maintenance of law and order, or for public welfare. So this can be the normative point of this pandemic privacy under pandemic issues. We know that privacy and the protection of personal information should be highly respected and protected by law, but under this emergency or pandemic situations, the authority or agencies should be able to have access to data or personal information. So in which sometimes that the right to privacy can be differently dealt with from traditional context. So let me go to section 2, which is about privacy protection under pandemic. So maybe we are sharing almost the same situations of pandemic, and Korea is also spending quite hard times. Korean people too. So Korea had up until now 3 major outbreaks of COVID-19 since early this year. So the first one was in February 2020. So this was related to some church church groups. The name was so-called Shincheonji. So this is somewhat different from the classical or traditional church, somewhat different kind of very strong, how to say, relationship inside the groups. And so this was basically based on Daegu area, which is southeastern part of Korea. So the first COVID. And then in May, so, another outbreak happened in Itaewon Club. Maybe some of you are familiar with Itaewon because which is the place for young people or many foreigners. So many new young cultures and art. So many things, including clubs. So and in May, so big outbreak happened in Itaewon Club. And quite recently, this month, there was a big protest against the government at the Gwanghamun, which is the main street of Seoul. And after that, or before that, so still another outbreak is happening in Korea, so COVID-19. So in that sense, in each outbreak situations, so the Korean government and the agency in charge of the COVID-19 broadly, hugely collected the personal information of the patients and people who had contact with the people, and sometimes that kind of gathering of information happened in a very new dramatic way. Like for example, in Itaewon Club case, so the agency contacted the mobile company, and by tracking the signals of mobile, so they gathered more than 50,000 people's information who were near that Itaewon Club at that time. So after that, they contacted them and suggested to get test of COVID. So we understand that because this is kind of highly emergency situations, but from the perspective of traditional privacy issues, so this is very abnormal and very unique situations. And as I showed at the introduction, so Korean Constitution was saying that privacy can be restricted by act when necessary for national security, the maintenance of law and order for public welfare. So in that stream, so we have this act, so-called Infectious Disease Control and Prevention Act. And Article 34-2 of that act is about disclosure of information during infectious disease emergency. So, and it is prescribing that when the spread of infectious disease is harmful to the level of the issuance of a crisis alert of caution level, so which is saying that some serious situation of COVID or higher, then the Ministry of Health and Welfare shall promptly disclose information such as the movement paths, transportation means, and medical treatment institutions and contacts of the patients of the infectious disease. So all of them can be categorized as personal information, which should be highly protected. And some of them are included in the so-called sensitive personal information, so which were treated more kind of sensitively with more higher care before. And Article 76-2 is about request for provision of information and verification of information. So it is prescribing that if necessary to prevent infectious disease and block the spread of infections, the Ministry of Health and Welfare or the director of the Korea Center for Disease Control can request agencies, other agencies, institutions, organizations, and individuals to provide personal information, including sensitive information. So, in that sense, under the restriction of kind of COVID pandemic, the agencies or the authority can broad and deep informations of person, and they can share and disclose that information to public to prevent the infections of the disease. So then I'll move on to section 3. It's about risk management and privacy. So as we all share, so now we are living in the age of risk societies, and so very different burden or different request is given to the government or agencies. So different from the traditional role of the state or government, so under these risk societies, the agencies or the government should make choice under uncertainty. So that means in the past, so even though at that time so the world was always very diverse and people's demand and request was very high, like in the police state or welfare state, but until then the goals and the tools to achieve that administrative goal has been somewhat direct and vivid. But in these risk societies, the goals of government and the tools to achieve that administrative goal is not the relationships of that goals and tools are not the kind of clear, and that means we are living in the age of uncertainty. But the issues, even under that uncertainty, so we have to make kind of daily choices, not just individually, but also collectively and nationwide. So in that sense, the traditional tools of agencies are heading into limits or handicaps. So we cannot deal with these issues with traditional tools or traditional logics of agency actions. So in that sense, so-called proportionality principles, which was quite popular, so especially in the civil regimes in the control of agency actions versus so-called precautionary principle is somewhat competing and conflicting with each other, and we need to think about which way to move on. So another issue is how we can develop some more well-functioning agencies or well-functioning state in the sense of rational choice in modern administrative law. The reason why most of us are viewing the market system in the private area and the democracy in the public or political politics area is that so somehow we can reach to the rational choice by collecting so each individual's rational choice both in markets and politics. In the market, that kind of rational choice are done by each individual's self-interest maximization kind of background, and in the politics area, so the rational choices are made by the delegation systems, like elections or moderate rules, or the kind of decision-making process and rules can guarantee some kind of rational choice, both individually and collectively. So, in that context, combined with risk society's issues, so we need to think about that rational choice again, because so this context or in making the choice under uncertainty, so we are facing with many, how to say, human biases. For example, availability heuristics or cascading or group polarizations or hindsight biases. So these are the findings of recent psychological or behavioral economics findings. So under that findings, in the real situations of choice, people are not making that kind of perfect rational choice, which were explained by modern economics or modern political theory. On the other hand, in the real situations, people are under kind of the many kinds of biases in their decision making, and so not just individually but also collectively or public aspect. People's choices can be quite different from traditional concept of rational choice. So in that context, we need to rethink or revisit. So what is the best way of administrative law and administrative agency actions? So this is the question which I want to raise and share ideas with you. So the privacy under pandemic issues is, I think, is highly related and highly combined with these topics. So the protection of privacy in modern risk society. Still we don't know how to find way out from this emergency, but to do it well. So we should not just make kind of good vaccines fast, but also we need to understand the real situation we are facing with, and we need to build up and find out ways to make kind of collective decision making process. So that is my kind of academic agenda on these issues. And like precautionary measures, like as I showed before about the wide and diverse way of collecting and disclosing personal information under pandemic, so which can be quite precautionary measures, and how we can harmonize that situations and measures with the protection of privacy, so under pandemic situations. So at this point, let me go to some more academic points, which is about liberty or freedom and right as fundamental conceptions of public law. So in thinking about liberty or freedom, so we cannot pass by without mentioning the Constitution of Liberty by Hayek. And so I will not go too much in detail about the story of these books, but at this book, Hayek categorized the liberty. So first of all, he tried to define the concept of liberty and freedom, or try to find out whether those two concepts are different with each other. But he concluded that from the classics, the term liberty and freedom are not kind of used as different terms. So freedom and liberty can be treated the same concept. And he introduced the Anglican liberty versus Gallican liberty. Maybe Anglican liberty is kind of British tradition of liberty, so which is more giving point to autonomous order or kind of conventions or experience of people. So the liberty should be based on the kind of the real lives of people. On the other hand, the Gallican liberty or French tradition of liberty means more like utopian related concept of liberty. So in this tradition, scholars say that the real liberty cannot be just found out from conventions or experience. So they explain that the real liberty or freedom can be built up by good functioning of state in the level of utopian societies. So these two different perspectives about freedom or liberty is very much highly affecting the different legal tradition of common law system versus civil law system. So I understand. So in that context, so we better think about the issues of choice, it's individual's choice and collective choice, and whether the choices can be rational choice or irrational choice. So if it comes to rational choice and under what conditions and what context the kind of rational choice can be made, not just in private area like in market system, but also in the public area, in the politics field. And in that context, how we can normatively define or understand the concept of liberty and the right of people. So, and I mentioned, so in this context, we should focus the relationship between individual choice and public choice. So this is kind of new, quite new story. So this is my way of thinking. So which means in the public law discussions or public law deliberations, how we can define the freedom or liberty of people, and how much can be the boundary of liberty of people. So and in what context, in what conditions, some choice of people should be restricted by state or other people under the name of infringement of other people's freedom. So in that context, I try to make two theses. The first one is like this. So if the rational choices of everyone are related to collective rational choice of public, and under that conditions, so each person's choice are in the boundary of liberty, and those choices should be protected as constitutional right. And the second thesis is this. When each individual's choices are related to collective irrational choice of society, and under that conditions, the state can intervene into individual choice with coercive power, which is based upon mutual coercion, mutually agreed upon, so suggested by Hardin at the story of the Treasury of Commons. And based on that two thesis, we can think about two kind of scenarios. So the first scenario is like this one. it's about like thesis one. That means the rational choices of each individuals are leading to collective rational choices. Like, for example, the perfect competitive market for economic efficiency, or political systems with perfect functioning for political efficiency. So both in private field and public field. So if the market mechanism or politics mechanism is well functioning until the level of perfections, then we can say that on the both regimes, each individual's choices, rational choices, can be leaded or corrected to public rational choices. So if that scenario is happening, then and under that conditions and situations, then each individual's choices should be respected, and that with as in the boundary of liberty. And in that boundary, the people's choice should be protected as right, whether it be constitutional or legislative right. So you can think about the same way in the issues of privacy right or the protection of personal information issues too. So on the other hand, we all know very well that in the real world or in the real market or politics, so that kind of happy ending scenario is not always the story. So we all know that the different story, right? Prisoner's dilemma story, or market failures, like for externalities or monopolies, or imperfect information issues, right? Or the tragedies of commons. So these are all kind of familiar concept. All of you know about this very well. But we can think about these situations from the perspectives of choice, rational choice, both individual choice and collective choice. So we can find out that these examples, prisoner's dilemma, or externality, or the tragedy of commons, in all of these situations, each individual, each person in the gaming are making perfectly rational choice in the sense that self-interest maximization issues. Even though each people in the societies are making purely rational choices, but very sadly, the collections of each individuals to the public are related to irrational choices of the societies, or sometimes tragedies of the commons, or the tragedies of the societies. So this is kind of the scenarios too. So if the situation is about scenario 2, then in that context, each individuals or each people's choice cannot be respected or treated as liberty or freedom, and people cannot claim or demand right on that kind of situation. So this is very simple, but my trial to think about these issues, the privacy under pandemic, right? How much liberty and right each individuals can have under these risk situations or COVID situations. So yeah, so this is the framework to think about these issues. I built up. So with that perspective, so let me come back to section 5, privacy as liberty and right under pandemic. So as I mentioned, so these issues are closely related to choices, individual choice and collective choice and state choice. So, okay. So with this framework or way of thinking, so we need to address these privacy issues. Right. In this sense, the public disclosure and collections by authority of personal information under pandemic. And so we can develop this story to the check and control of agencies' discretion issues, and maybe later in the future, so these agency actions will come to the court and will be reviewed by judiciary, and in the context, what kind of tools or logics can be used to deal with issues. So traditionally, especially in the civil law traditions, the main tools of addressing these issues are the proportionality principles. But I'm not sure. So how we know that proportionality principles is based upon the belief that at the final stage, so the judges themselves can fully understand the situations and can make decision about so what was the best choice for the agencies of that kind of choice. But so I'm not sure in the new age of uncertainty or risk societies, or in the age of pandemic. So how much judges can find out the right answers for that kind of questions. So in this sense, so we can compare the proportionality principles versus precautionary principles. But in addition to that, even though it's not in the slide, so we can think about the so-called Chevron difference principles, which is more popular in United States administrative law. So that is all about so how to build up the finding ways to reach to collective rational choice in these issues. So overall, so these issues are related to privacy in risk societies. So maybe I can go more in detail about every topic, but yeah, somehow I came to the final slide. Well, I think I came somewhat earlier than the expected time, but yeah, so I will finish my lecture until now, then move on to Q&A sessions.